The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Thank you, Madam Clerk. Good morning, everyone. Our first case for today is State versus Cheeks, and we will hear from the appellant.
May it please the court. My name is Assistant Appellate Defender Dan Schatz, and I appear today on behalf of Thomas Cheeks, the defendant in this complex case, factually, legally, and procedurally. It's the kind of case that calls to mind the old law school cliche and admonition about not letting hard facts make bad law. It's my intention to discuss the first two issues in the brief, and of course to answer any questions your honors may have about the third issue, but otherwise I don't expect there will be time to talk about the third issue. I would like to reserve 5 minutes for rebuttal. Before I get into the get into the legal analysis, there are a couple of things in the record that I think it's important to bring up and keep in mind as we're discussing these issues. And the first thing I want to call the court's attention to is how this state presented this case to the grand jury. The murder indictment, of course, is a short form indictment. But if you look at the two child abuse indictments, the state alleged an intentional act of child abuse by Mr. Cheeks placing his hands around the child's throat and strangling him, causing death. And in the second indictment on record page 6, the state alleged that the failure to provide sufficient medical treatment and sufficient and proper nutrition was a grossly negligent act of omission. Likewise, at the trial, and at the very beginning of the trial court, and this is on page 18 to 19 of the transcript, asked the state to submit proposed jury instructions. And then when they get to the charge conference, the trial court notes that the state has requested P&D murder, felony murder based on the intentional child abuse, and murder by torture. The theory of murder by starvation does not come into play until the trial court brings that up himself about 35 pages into the charge conference. And that's really where the first mention of the theory of murder by starvation. And so when the medical examiner is testifying, I think the state is eliciting evidence and presenting his testimony to support that strangulation is the cause of death, not starvation. And likewise, thinking back to the original autopsy report, when the detective gets that report back, his reaction to that report is not, okay, I now have enough information to charge Mr. Cheeks with murder and we have a death by starvation that's clearly shown. His reaction is he needs more information, and that's what leads to the interrogation that leads to this whole strangulation theory of murder. So turning to the elements of murder by starvation, we had at that time, and before this case, that statute had been on the books for 120 years, and there has never been before this case a reported case involving this theory of murder. So we have, somewhat ill-defined and it's just never been developed in the case law. What exactly does murder by starving mean? But we have two cases from the Court of Appeals, State v. Mason and State v. Fritch. And then Fritch, of course, comes up to this court. And that basically explain that the distinction is that if the defendant commits the offense with malice, it's murder. And if it's not, it's manslaughter. And both Mason and Fritch were involuntary manslaughter cases, and they were based on theories, of negligence and of non-intentional starvation, as far as we can tell. But the case law in general is clear that the statute that divide, in 1893, when the state divided murder into degrees, it did not change the definition of murder. Murder retained the common law definition of an unlawful killing with malice aforethought. And malice, because the statute did not change the definition of murder, and in fact, the way the statute is worded, it's just a murder that is committed by any of these enumerated means shall be first-degree murder. So it has to be a murder before the statute categorizes it as first-degree murder. And so our contention principally is that malice remains and has always remained an element of murder, even in the murder by starvation context.
Are you saying that malice cannot be inferred in a murder by starvation theory of a killing?
Well, as a factual matter, malice could be inferred, but the finder of fact would have to make that inference. Our case law is clear that inferences are for the finder of fact. The state, in its brief, brings up this notion that malice is implied in law. And the problem with that is, unlike some of the other enumerated categories, there have always been cases, the recognition prior to the adoption of that statute, the common law recognized that this category of death, of a homicide, could be negligent, could be manslaughter. This court first talked about the implied in law theory in this Crawford case with regard to the murder by torture theory. But the murder by torture theory, the elements there include a mens rea element that is more severe than mere malice. It's the intentional infliction of grievous pain and suffering for the specified purposes in which I think are punishment or sadistic pleasure. So there's already, when a jury finds that finding more or less encompasses a finding of malice. But
in consideration of the circumstance wherein murder by starvation contemplates that over some significant duration of time, which is the state's theory here, that implies malice, what is your response to the duration aspect of a murder by starvation in terms of the implication of malice?
Well, I think the duration of time is a factual component, again, that would have to be assessed by the trier of fact. And it can, depending on how one looks at the facts and the circumstances in this case or in another similar type of case, it can cut both ways because, the parents were providing food to this child. It just wasn't enough. And that could be a reflection of negligence, of bad parenting, which of course there's plenty of evidence of that in this case. And again, keeping in mind that at least at the grand jury stage, that's exactly what the state alleged in the child abuse indictment, is that it was gross negligence to fail to provide this child with sufficient food and nutrition. So I think the duration itself allows for the possibility of a negligent situation, and that would clearly be an involuntary manslaughter. And one of the things I put in the brief was in fact that the opposite. When you have a case like the facts of the Evangelista case, where there's a complete deprivation of food and water, and the death is it took, I think in that case, 2 days or 3 days, the complete deprivation over the shorter period of time, that's never going to be negligent. So if starvation were defined that narrowly to mean complete and total starvation or deprivation of water, then that would allow for the inference, for malice perhaps to be implied. because that's just not something that's ever going to happen negligently. And I do want to get into, discussed in the reply brief, this whole concept of malice being implied in law is at least called into question by the whole United States Supreme Court line of cases, starting with Sandstrom v. Montana.
Is into Mr. Shantz to move to that for a second, move to that issue for a second. Isn't malice implied by law really not an implication or a presumption so much as a statement that as a matter of state law, there's no requirement that there be a separate malice?
Well, that is certainly how this court's precedents have treated the issue.
And didn't they do that basically to avoid the kind of Sandstrom problem that you discussed in your brief?
Well, I'm not sure really, as long as malice is recognized as an element of the offense, I don't think that can necessarily avoid the Sandstrom problem. I think it's just kind of talking its way around the Sandstrom problem. But
are you arguing then that a decision like, I think it was, there's enough decisions here, I'm going to get them wrong, so correct me if I cite correctly, but I believe it was it Crawford that said that murder by poison didn't require a separate showing of malice. There is such a case, regardless of whether it's Crawford or something else. Does that case involve a Sandstrom violation?
Well, again, Crawford was the case about murder by torture, and then Smith made that same application to murder by poisoning. And as I mentioned earlier, I think for murder by torture, this problem doesn't arise because the mens rea element of murder by torture, it necessarily encompasses malice.
What about murder by poison?
Well, again, I don't think it's something that needs to be decided in this case, but I think that it is possible that case is in conflict with that line of United States Supreme Court cases, which were never brought up and discussed in that context. So I guess that's an open question that might have to be decided another day. But
as a matter of statutory construction, I mean, just looking at the language of 14-17, and I heard your argument to the effect of it starts off by saying a murder. So putting that argument aside, is there any reason, and I realize you're not waiving it or forfeiting it, I just want to not make you repeat it again. Is there any reason as a matter of statutory construction for differentiating between a killing by starving or a murder by starving as compared to a murder by poison or a murder by torture?
Yes, Your Honor, and that goes back to the law that was in existence at the time that the statute was adopted, which recognized that unlike a murder by torture or a murder by poisoning, a death that is caused by malnutrition or not providing enough food could be manslaughter. That was already recognized. That's a common law, concept. The case law in Mason and Fritsch, they refer to secondary sources, and there's sort of a recognition that the case law, the common law generally recognized that possibility at that time, whereas there are cases that always say, lying in wait is another example, where there's old case law that says that implies malice at law.
What do you make of the state's distinction between an intentional starving and a negligent starving?
Well, the state actually refers to a willful intent as implying as what is the trigger to imply malice at law. And willfulness is willfulness, malice, intent, they're all recognized as different mens rea states. But willfulness is a question for the finder of fact. And the case I sent up in the Memorandum of Additional Authority, the CLH case, recognizes that point in Justice Berenger's dissent. And I don't think the majority really takes issue with that the question of willfulness is one for the finder of fact. And, you know, in that case, of course, the trial court had made an express finding that the respondent in that case had willfully done whatever it was that was of significance in that case. And the court, you know, it was a question of whether the facts supported that. But there's no question that willfulness is for the finder of fact. So whatever trigger that differentiates murder from manslaughter in this context, it you know, requires findings of fact from the fact finder. And you know, I think it's important to consider that you know, in the order and the verdict, the trial court did say that Mr. Cheeks intentionally starved the child, but there's no mention of malice, there's no mention of willfulness. And given that the trial court acquitted Mr. Cheeks of premeditated and deliberate murder, his use of the word intentional there doesn't mean specific. It's not a specific intent use of that word. It's more of a general intent use of that word, because otherwise that couldn't be reconciled with the acquittal of murder by premeditation and deliberation. And again, I think this is important because there is a lot of evidence in this record that could have supported a finding that this was just really bad parenting. And again, the state.
Well, is there any evidence from which you could make a finding that it was more than bad parenting, that in fact this was done something that, using the late term, was intentional?
There was certainly. You know, but
so
again,
where does that leave us if there is such evidence? If the trial court in a non-jury proceeding found guilt but didn't use that word in the finding, does that mean you remanded? If we were to buy your argument, do we remand it for findings? Is the failure to make a finding double jeopardy? Where do we wind up?
Well, that's an interesting question, Your Honor. And you know, I think talked about this in the brief and more so in the reply brief, that this is the equivalent of a special verdict. And the case law is very clear that in a special verdict, an appellate court is not allowed to make its own inferences from the facts that the finder of fact did not make in the verdict, in the special verdict itself. Now, as far as the remedy, you know, this is totally first impression, and this case, you know, I haven't really talked about it in the brief because it's not about, you know, the legal error, but we have no procedure for bench trials. The legislature, when they enacted the procedure to waive a jury trial and have a bench trial, did not enact any procedural statutes about how a bench trial should be conducted. And that kind of leaves us a little bit at sea on that point. I do think, you know, the Court of Appeals was very clear that it was going to review, it did review this order and verdict under the standard for, you know, when a trial court sits as finder of fact, and you know, it's whether the evidence supports the findings and then whether the findings support the conclusion. But because it's a verdict, I don't necessarily, it's not clear to me that you could remand for further findings. In fact, it may be, I think, certainly, I was thinking the result would be a remand for a trial at which a new finder of fact would have to make new findings of fact. And since we're moving along, if I may, I want to move over to the cause of death issue, because on that one, I think at least it's clear that if I'm correct, that remand would be for a trial for second-degree murder or involuntary manslaughter. And so the question is, does it require expert testimony to say that this child died of starvation? And we think the answer is clear. The cases hold that that's a general rule, that expert testimony is required to prove cause of death. And there's a limited exception where there have been observed injuries inflicted by the defendant that immediately dropped a healthy person and caused them to die. But none of those cases involve this kind of internal, what's going on, you have this chronic condition where this child had been in this condition for some period of time, but had been alive. You have the medical examiner reaching a contrary conclusion regarding the cause of death, which is a factor that's not there in any of those cases. And in the original autopsy, even before the medical examiner moved on to this idea that it was a strangulation death, he said the cause of death was complications of a genetic abnormality. He then identified two competing, what he called immediate causes of death, one of which was malnutrition, and the other was this child's well-documented seizure disorder. And he said it may have been the one, it may have been the other. And so the very idea, and in his testimony, he described this as a complicated case. And so the very fact that the medical examiner could look at this and conduct an autopsy and reach these kind of conclusions itself demonstrates that this is not the kind of case that fits into the exception that's talked about in the Minton case and the cases that follow from Minton, where they say, well, if it's obvious to any lay juror what the cause of death was, you don't need expert testimony. I mean, because if on this evidence, if it could be obvious to any lay juror, you'd have to ask yourself, well, how could it be, what is that? What do you make of the medical examiner's opinions? What do you make of the district attorney submitting this case to the grand jury with allegations that it was strangulation that caused the child's death, and that you had this negligent failure to provide sufficient food, which led to failure to thrive. And I think just the fact is, this is not a case that fits in that exception. And I think it's important, the Holly versus Axe Inc. case that I cite in the brief, they talk about the idea that a medical examiner's testimony or a doctor's testimony that something could have caused a medical outcome or might have caused a medical outcome is not sufficient to prove, even under the less strenuous preponderance of the evidence standard, it's not enough to prove causation.
Skip that real quick. The state points out that the doctor testified that it, quote, most likely the explanation is that he died from malnutrition. Are you saying that an opinion that it's most likely is not sufficient?
Well, Your Honor, I think you have to go back and look at exactly what the medical examiner said. This was on page 481 of the transcript. And what he said was, just looking at the child, I thought the most likely explanation was that, malnutrition or starvation. But then he immediately goes on to learning the information about the genetic disorder, the seizure disorder. And so he's just saying that was like his initial impression, from looking at the child. But that's not the opinion that's derived from his use of his expertise, because he can, that was very preliminary. He talked about how gathering all this information, there was actually about a 4 or 5 month delay from the autopsy itself until he generates the report. And he talks about the fact that he's getting information about the genetic disorder, he's getting information about the seizure disorder. And ultimately, the proof of the pudding is in the report he generated. And there he says flat out, and this is on record page 17, based on the history and autopsy findings, it is my opinion that the cause of death in this case is complications of a genetic abnormality. So
right. On the next page, he somewhat amends that and says that strangulation is the cause, but then he says nutritional and medical neglect contributed. Why isn't, when the doctor's opinions are sort of all around the map, isn't that decision of what to believe up to the trier of fact?
Well, Your Honor, in his testimony, Dr. Prevett explained very specifically how the malnutrition would have contributed to the death by strangulation by making the child less able to resist and more vulnerable to being strangled. But the medical examiner, he also testified that all of the organs were functioning normally. The trial court did not find that the starvation contributed to the child's death by strangulation. Which is what the opinion is really saying.
Isn't that exactly said in the very last line of the report on record page 18? After he says that death was strangulation, then he says medical nutritional neglect contributed to this death.
This death by strangulation is what that is immediately referring to, but that's not what the trial court found. And I would add, the trial court in its order, there's nothing in that order that suggests the trial court is basing that, is making a finding based on anything Dr. Prevett said about cause of death. And the trial court's comment to Mr. Cheeks after the judgment was entered, that he's just looking at the picture. He says the picture speaks more than 1,000 words. There's no way this child wasn't starved to death, or that you didn't starve this child to death. So he's not. I don't think he's basing that on Dr. Prevett's opinion, which is, again,
does he have any explain that in his findings of fact? If his job is to take credibility and decide what to believe, does he have to explain why he believed certain things and not others?
He doesn't, but again, the opinion that's in the report and and it also matches Dr. Prevett's trial testimony, is that nutritional and medical neglect contributed to a death by strangulation. And the trial court did not find that there was a death by strangulation. I don't think there was ever any opinion that really supported the idea that from any expert opinion that supported the idea that this child died of starvation rather than strangulation. And I see that I'm well into my rebuttal time, so unless there are more questions, I will reserve the balance for my.
Thank you, counsel. We'll hear from the appellee.
Good morning, Your Honors. May it please the court, my name is Kimberly Callahan. I'm a Special Deputy Attorney General for the Department of Justice, and I represent the state in this matter. Malachi Golden weighed a mere 19 pounds when he was found dead in his residence, nearly half the size of a typical 4-year-old child. His skin was sagging and nearly every bone in his body was visible. There was open sores that covered his groin, his legs, and his back. Seasoned law enforcement officers were startled by his appearance and did not even immediately recognize him to be a human being. The photographs of Malachi's emaciated condition speak for themselves. And other evidence at trial overwhelmingly shows that he was murdered by starvation and repeatedly and consistently abused by the defendant. Why? Because the defendant wanted Malachi out of the picture. Now, I'd like to start where we just left off. Whether starvation was the proximate cause of Malachi's death is simply a question of the sufficiency of the evidence. The standard of review is well established and well known by this court. It must look at the evidence in the light most favorable to the state, resolving any discrepancies or contradictions in its favor. Now, there's an added layer of analysis here as to what the state has to show as to cause of death. And the state's position is whether expert testimony was required or not in this case, the state presented more than substantial evidence that Malachi was intentionally starved to death. This court's precedent cited in both of our briefs on whether expert testimony is necessary to establish cause of death asks a simple question. Was the cause of death apparent to a reasonably intelligent person? Or stated differently, was there an observed wound that was obviously mortal in nature? And the answer to those two questions is a resounding yes in this case. The malnutrition.
So again, Ms. Callahan, just to make sure I'm following you, your argument is did a lay trier of fact, without any kind of medical evidence, is capable of making a cause of death determination in this case based on the photographs?
I'm sorry, Your Honor. Could you do that one more time? You're breaking up just a little bit.
Sorry about that. Is it your argument in essence? Is it your argument in essence that a lay trier of fact can make a cause of death determination in this case based on the photographs?
Based on the photographs and the circumstances surrounding Malachi's death that was introduced.
The cases, do you know of a case that holds that as compared to a situation in which there is a direct wound that is observed to have been committed by the defendant?
I don't know that there is a case that is akin to this situation. I will candidly acknowledge that there are some factual distinctions between this court's precedent in the cases cited in the brief where there is one mortal wound that killed the victim instantly. Here we have a different situation. We have an intentional death by starvation, which necessarily is required or would occur over a period of time, whether it be days, weeks, months, or years. So this case is factually distinguishable. But what the precedent says from this court is the cause of death apparent to a reasonably average person? And looking at the photographs of Malachi's emaciated body and hearing the testimony of the circumstances leading up to his death and finding his body in this condition, there is no need for expert testimony. Like I said, these photographs speak for themselves. There was plenary testimony about the condition of his body. Then you have the circumstances surrounding his death. You have evidence that from the very beginning of their relationship, Tiffany was going to leave defendant because he was mean to Malachi. That quickly turned into physical abuse and beating him, leaving marks all over his body. The defendant convinced Tiffany to take Malachi off of his seizure medicine, even though he was doing well and clearly needed it. He convinced her to stop taking Malachi to the doctor so that they could hide the physical abuse that was occurring. In the few months.
Let me just jump in here and ask you about your argument about that you can look at the body and it's readily apparent. I'm just wondering, are you saying, is it the state's position that whenever there's a badly emaciated body that it's reasonable to presume or infer that the person died of starvation as opposed to, say, a seizure without an expert testimony?
I think in this particular case, not in all cases of starvation, in this particular case, the condition of his body and the circumstances leading up to his death, which I was going into. So the photographs, perhaps not in and of themselves, but the photographs plus the other testimony in this case shows that
he died of starvation as opposed to a seizure, say.
I would say that, yes, that you can look at these pictures and hear this evidence and at least know that starvation was a proximate cause. It may not be the only cause, but was a proximate cause of his death because of the severity of the malnutrition in this case. So our argument is not in every starvation case where there's an emaciated body that this rule would apply. But here, where you have the condition of his body plus other evidence leading up to his death, it's sufficient for a layperson to be able to discern cause of death. And I want to talk about some more of that evidence here. We have, in the preceding months to his death, therapists that are coming to the home and trying to work with Malachi on his feeding. One of the therapists was so concerned that he was going to choke himself because when she would work with him on his feeding techniques, he was so ravenous and he would eat so fast, she was worried that he was going to choke. You have testimony from another therapist just several months before he died that in January of 2015, she noticed that Malachi was appearing very thin and brought that up to Tiffany and asked whether Malachi was under the supervision of a doctor. And Tiffany lied and said yes. There were two other instances where the therapists were there to have a therapy session with one of Malachi's sisters. They arrived in the afternoon and both Malachi and his sister had not eaten yet, and the sister was fed at that point and Malachi was not. You have evidence that both Tiffany and defendant admitted that he was not being fed properly in the last couple months leading up to his death. The defendant said that he rarely fed him more than once per day, that he was annoyed with him, he was frustrated with Malachi, that he would ignore him and leave him in his playpen. So all of that evidence, plus the condition of his body, a reasonably intelligent person would be able to discern that Malachi was intentionally starved to death here. But even assuming arguendo that expert testimony was necessary in this case, there's plenary evidence for the trial court to make that determination here. As I said, we've had multiple witnesses describe Malachi's body. He's half the size of a child, of a typical 4-year-old. His organs are half the size they're supposed to be. He was chronically dehydrated for at least several weeks. You have evidence of malnutrition with the head being too big, his sunken eyes, his wasted appearance. And you have a medical examiner who was at the scene, write in her report that his body was severely emaciated. You have his treating physician, Dr. Robinette, testify what would be the cause of Malachi looking this way, or what would cause a child to look this way. Her answer was starvation. And then you come to Dr. Prevett's testimony. And I would like to be clear, Dr. Prevett testified over 100 pages of testimony in this case. The defendant wants to usurp one single sentence of his testimony and say he unequivocally testified that strangulation was the cause of death in this case. So I'd like to review his testimony. The state takes him through, he describes the condition of the body, the tests that he ran to determine that Malachi was chronically dehydrated. He says, it is just looking at this child, I thought it was reasonably likely that he died from malnutrition and dehydration. Now, I had some other concerns. I listed a genetic abnormality because I had other concerns about his seizure disorder and his chromosomal defect, but I didn't have enough information because his medical care for those conditions ceased in 2013 after the defendant and Tiffany got married. So what he said was malnutrition and dehydration was the immediate cause of death, and there is a competing cause of death, his seizure disorder. And what he meant by that was he wasn't sure that a child like Malachi would be able to feed himself. So he couldn't feed himself and he couldn't drink water, which would contribute to the malnutrition and dehydration in this case. After he makes the findings in the autopsy, the defendant had made a statement, his third statement to the police, which implicated him, in which he gave various versions of how Malachi died. One of the versions was that he strangled him. He put his hands around his neck and watched Malachi take his last breath because he was moaning and he wanted him to be quiet. Now that, based solely on that statement, Dr. Prevett amended his report and opined that asphyxia was the immediate cause of death. But as Justice Hudson pointed out, malnutrition and dehydration also contributed to his death. Now, interestingly enough, on cross-examination, it was the defendant that got Dr. Prevett to testify that there were no physical findings of strangulation. There was no bruising around the eyes or the neck, as would occur in a homicidal strangulation. He had no reason to believe that strangulation occurred at the time of autopsy, or he would have done a neck dissection, and that if the defendant's statement was not true, there was no objective scientific evidence that would support strangulation in this case.
Ms. Callahan, in your view, is testimony that a particular factor, I think the word was contributed to death, is sufficient to support a finding of proximate cause?
Yes, Your Honor. There can be more than one proximate cause of death.
I mean, but is the mere fact, I'm not sure that's the right word either, but is the fact that a particular cause contributed, using that word, is that sufficient? Is contribution sufficient to support a finding of probable cause? If it is, what would you cite in support of that statement?
I don't know that there is a case that I can cite to you that says a contributing factor is sufficient to support probable cause. But I think in this case, regardless of what his amended opinion said, the trial court, his opinion was still subject to credibility determinations and the weight that the trial court was going to give to it. The trial court, in any witness or the fact finder, the trial court in this instance may believe all or part or none of the witness's testimony. And here it's clear that the trial court did not believe defendant's statement to law enforcement that he strangled Malachi. That was the basis of premeditation and deliberate murder, which he was found not guilty of. It was also the basis of child abuse, intentionally inflicting serious injury, both of which he was found not guilty. The defendant on the stand, once after Dr. Prevett testified, came on the stand and recanted his testimony and said, I didn't do any of that. I was trying to fill in the blanks for Detective Brienza. I didn't starve him. I didn't strangle him. I did none of the things that I said previously. And so the trial court weighed all of the evidence in this case and found that the credible evidence, the evidence that the fact finder believed, was that the proximate cause of Malachi's death was intentional starvation. And as the fact finder, that's his province. We're in sufficiency of the evidence, and so that is a relatively low bar here. We're looking at the evidence in the light most favorable to the state, and that so long as it is sufficient to go to the fact finder for a determination for beyond a reasonable doubt, the weight of the evidence is for the fact finder. And the trial court clearly believed that defendant intentionally starved Malachi in this case based on the totality of the evidence, the photographs, the lay witness testimony, and Dr. Prevett's testimony. It is true that the trial court didn't make any specific findings of fact about his original opinion or his amended opinion, but he makes several findings about the condition of Malachi's body and that the defendant intentionally starved him to death. Any person would know, looking at the condition of Malachi's body, that he needed medical attention and that he was basically wasting away, and the defendant watched him do this. And that intentional act rose to the level of a homicide in this case.
How should we regard the medical examiner's express reliance upon the defendant's representation that he strangled the child to death relative to these other theories that were put forward by the medical examiner as to the cause of death?
Well, I think that all goes to the weight of his testimony and whether the fact finder ultimately believes, as I said, all of his testimony, part of it or none of it. The trial court found the defendant not guilty of these other crimes based on his alleged strangulation of the child. So the trial court clearly did not believe that the defendant's statement that he strangled him was credible. And so you go back to Dr. Prevett's testimony, and his testimony is based, his amended report is based solely on the defendant's statement. And so you have the judge considering what he believes is an incredible statement as a basis of an opinion. And it's within his discretion to reject that and say, I don't believe that strangulation was the cause of death here. The defendant recanted on the stand. The defense counsel brought out information that there was no physical findings of strangulation here, and that if defendant's statement was untrue, there was no objective scientific evidence that he was strangled to death. And so the trial court hears all of this and gets to make the determination of what he believes is the actual cause of death.
Well, from the state's perspective, I was concerned as to the state's position as to whether or not, in light of the original determination by the medical examiner as to the chromosomal deficiency of the child, coupled with the express representation by the medical examiner that there was reliance upon the defendant's position about strangulation, and all of this in terms of whether or not there would be a need for us as a court to consider that expert testimony was necessary to determine the exact cause of death. What's the state's position on that?
Your Honor, there is some conflicting points in Dr. Prevett's testimony about what caused his death. Our position is that when you look at the photographs and you hear the lay testimony, those together make expert testimony not necessary in this case. But even if we do need expert testimony in this case, the trial court had plenary evidence to support intentional starvation as a proximate cause, looking at Dr. Prevett's testimony as a whole rather than one singular statement that he made based on an incredible report that the trial court did not believe. So moving on, if there are no further questions as to the first issue, I would like to move on to the second issue. I think maybe both briefs in this case make this issue seem more complicated than it actually is. I don't disagree that the difference between murder and manslaughter is the element of malice. That's how it has been since common law. That's how it is today. The question in this case is, what showing does the state have to make for the element of malice? And this court's precedent in State versus Crawford and State versus Smith answer this question. Those cases aren't starvation cases, but they're murder by torture and murder by poison, the other enumerated first-degree murders under 1417. The defendants in those cases made the exact same argument that the defendant is making here, that in murder by torture and murder by poison, the trial court has to instruct the jury on the element of malice. And because there was no instruction on malice, there was no finding of malice, and therefore these first-degree murder convictions had to be reversed. What this court said is, no, we're going to look at the common law definition of murder. Common law definition of murder is an intentional killing with malice, either implied or express. And then it analogized murder by torture to felony murder where intent can be transferred. And this court said that torture is a dangerous activity of such reckless disregard for human life that, like felony murder, malice is implied by law. The commission of torture implies the requisite malice, and a separate showing is not necessary. The same exact argument was made in State versus Smith. That was an intentional murder by poisoning. The court again said the elements are an intentional poisoning that proximately caused the defendant's death. And when you commit the act of an intentional poisoning, malice is implied. There doesn't need to be a separate showing.
Can I ask about State versus Fritch? Is that, and how you would distinguish the facts there? Because on this point, because there, the medical examiner also found the cause of death to be starvation, malnutrition, but malice was not sort of automatically inferred from that. That was a involuntary manslaughter conviction.
Sure. Well, in that case he was charged. He was never charged with murder in that case. It was involuntary manslaughter, and the court discussed whether there was evidence that was sufficient to support the state's charge of involuntary manslaughter. And there you do have some evidence that the victim was starved. But here, what's different is that you don't have allegations of negligence. This was an intentional starvation. Here we have evidence that, and I believe the defendant, he can correct me if I'm wrong on rebuttal, but I believe he actually conceded that there was plenary evidence that this was an intentional starvation. You have defendants' repeated abuse of Malachi. You have they admitting that they weren't feeding him properly. That defendant ignored him. He didn't feed him more than once a day. He was frustrated. He wanted him out of the picture. He didn't want to have to deal with him. That evidence, at least according to the opinion, was not there in the State versus Fritch opinion. So I don't disagree that there could possibly be negligent starvation. That would be a separate crime of involuntary manslaughter. But North Carolina also recognizes that there is first-degree murder by starvation when there is an intentional act of starvation. And once we have sufficient evidence of an intentional act to starve, malice is implied and is conclusively proven at that point. So that element is met. There's no separate showing or separate element that needs to be met.
If I understand you correctly, you're saying it's not the fact of death by starvation alone. It's the fact that there's evidence that it was willful and intentional. And once you have evidence of willfulness and intent, then the law counts.
Yes, Your Honor, that's correct. The murder is an intentional killing with malice. The malice here is implied. If there was an unintentional killing without malice, and it was based on gross negligence, then it would be a separate crime. It would be involuntary manslaughter, as it was found to be in Fritch. But that's not what we have here. We have an alleged intentional starvation, and the evidence supports that. And I believe the defendant agreed that there was evidence to support that here. And that's really where the analysis can stop at this point. If malice is implied, this court doesn't need to get to the issues of whether his findings were sufficient, or whether this was ex post facto, or whether there was plain error in the jury instructions.
Now, Ms. Callahan, again, just to make sure I'm following you, you repeatedly said malice is implied. My understanding is that we're talking about implied in law as compared to implied in fact.
Yes, Your Honor.
And implied in law, at least as I understand it, and the ultimate question is my understanding correct? And if it's not, don't hesitate to tell me. But my understanding of implied in law is that that means that there is no need for a separate showing as a matter of fact that malice existed. Instead, the implied in law means that it's there just as a matter of the other factual elements of the offense, separate and apart from the specific showing of malice. I probably didn't say that very well, but I hope.
No, Your Honor, I agree with that. Yes. When it's implied in law, there is no separate showing that needs to be made here. And once we make a showing of intentional starvation and that starvation caused the defendant's death, then malice is implied by law. There's no separate showing that needs to be met. There's no separate jury instruction that needs to be had or separate finding. I want to talk a little bit about the definition of starvation, which again, it doesn't really need, we don't really need to get to this issue, but just in case, Evangelista basically gives the definition of starvation, albeit in dicta, but starvation is the deprivation of life-sustaining food and water. Now, in that case, it was the complete deprivation of food and water in that case, but that is one end of the spectrum. And it would take, a human being that is an adult and a human being that is a baby, different times, all the cases would have to be based on the evidence in that case. There's no bright line rule of where starvation begins and ends. So anything past or anything less than a complete deprivation of water would simply just be a jury question. Unless the court has any other questions, I'd like to take the last minute to sum up. The evidence in this case showed that the defendant intentionally starved his stepson Malachi, and he repeatedly, consistently abused him. The trial court correctly found, based on all the evidence, that he was guilty of first-degree murder and negligent child abuse, and the state would respectfully request that this court affirm the Court of Appeals decision in this case. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
May it please the court, I have a couple of quick points I'd like to make. First, with regard to the element of malice, the state in its argument acknowledged that malice is and has been and remains an element of murder. And this gets to Justice Ervin's questions about implied in law, but if our case law has developed in a way that there can be an element of the offense, but it does not have to be presented and does not have to be found by the finder of fact, then I do think that law has developed in a way that is inconsistent with how the United States Supreme Court has developed the laws regarding jury trials and due process and findings beyond, that the finder of fact has to find every element beyond a reasonable doubt. And it's an extraordinary thing the very idea that there can be an element of the offense, but the finder of fact doesn't have to find it beyond a reasonable doubt, suggests that to the extent our case law does support that notion, it's gone in a wrong direction. And turning to the point that Ms. Callahan made, I did acknowledge that there was evidence that could support a finding, but the trial court did not find willfulness, did not find malice. And so the fact that there was evidence that could have supported such a finding is not the deciding factor. And finally, the last point I'd like to make, turning to the cause of death issue, is I think the idea that the trial a finder of fact can believe some part or none of the evidence, I don't think it means that the trial court, the finder of fact, can pick and choose and land on a meaning that is different from what the witness is saying. So when Dr. Prevett says that malnutrition contributed to a death by strangulation, I don't think that means the trial court can just say this death was caused by malnutrition if the trial court doesn't accept that it was, as a contributing factor to strangulation. And then we also get the fact, which we really haven't gotten into, that this was a formally held opinion. I don't think when the trial court disagrees with the opinion stated in the testimony, I don't think that allows the trial court to say, well, I'm going to believe the prior inconsistent statement and make my findings based on that. I see I'm virtually out of time. So with that said, I will simply ask the court to reverse the Court of Appeals and remand with instructions for a new trial. Thank you.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.